The first thing Kylen Dalton ever learned about courtrooms wasn't a statute, a case name, or a rule of evidence. It was air. Courtroom air behaves differently from the air anywhere else. It stretches and thins and thickens on command. It holds its breath when a robe tilts its chin. It leaks laughter through teeth in the gallery when the powerful decide something is funny. It can make a person feel light enough to float or heavy enough to sink with nothing more than a sigh from the bench. Today the air was thick, like water resisting a swimmer's hand. Kylen stood at the defense table with his chin lifted just enough to communicate that he wasn't afraid, but not so much that a judge could call it defiance. He wore a collared shirt a size too big, the cuffs mildly frayed where another boy's life had worn them first. 19 years old, 2 charges on the docket that sounded angrier than they read on paper: grand theft auto and resisting arrest. Both had been spoken about him already in corridors and copy rooms and cars idling outside the courthouse. He could feel the words clinging to him now as if they'd been printed on static film and slapped to his back. Judge Warren Granger sat as if the bench had been measured and cut to the length of his particular slouch. He leaned back, one elbow on the armrest, fingers drumming a lazy metronome against varnished wood. A pair of half-moon glasses perched low on his nose gave him the authority to peer and the license to dismiss without moving his head. His mouth did something mouths do in rooms where outcomes often arrive pre-assembled. It hovered between a smirk and a sneer, as if it hadn't yet decided whether to be entertained or offended. "You think you're some kind of legal expert?" the judge asked, his voice bone dry, amusement threaded through it like a hairline crack. "This isn't a debate club, kid." The air released a controlled chuckle, and it came from predictable corners. The bailiff, big kind eyes that had watched too much, let out a breath that approximated a laugh. The court reporter's fingers never stopped their patient sprint across the keys, but her shoulders made a micro-shrug that played like a smile. A couple of suits in the gallery, men who looked like they'd left a second, shinier watch at home for fear of seeming vulgar, smiled the way people smile when the punchline costs someone else. At the state's table, Assistant District Attorney Miles Carruthers allowed himself a small, symmetrical smile that didn't quite reach his eyes. He had the kind of suit that obeyed, the kind that knew where to crease and when to drape. His tie sat perfectly, as if the knot were lightly glued in place. Kylen didn't blink. That was the second thing he'd learned about courtrooms. Blinking, like silence, is a tool. He had never planned to stand here as a defendant, but he had learned the language of these rooms the way some kids learn new video game maps, by repetition and curiosity and staying up late because the next level might reveal the trick to the whole design. While his friends memorized stats and song hooks, he memorized case names and phrases like preponderance and reasonable. While they chased high scores, he chased the feeling that arrived when the shape of an argument clicked and a door that had seemed flush against a wall swung open. He had not planned for today. He had assumed the first time he spoke in a courtroom would be from the right side of the bar, wearing someone else's confidence and a badge that said, "Intern." Life had mixed up the order. But he knew the room. He recognized the script. He'd learned most of it at a small kitchen table under a tired ceiling fan, from a woman who wore her hair tied back like a promise and her frustration folded into neat sighs. Darlene Dalton, his mother, had been a paralegal for over 20 years, which meant she carried the law home in tote bags and in her shoulders. She never broke confidences. She didn't have to teach him what mattered. "They cut corners, Kai," she would say, dropping a stack of photocopies on the chair as if the chair had asked to be useful. "Not all of them. But enough. Enough to make a pattern if you know how to hold the pieces together." She told him about chain of custody forms with gaps, about judges who had favorites and didn't bother hiding it, about defense attorneys who mistook a fast loss for good lawyering because it made the docket lighter and dinner earlier. He listened and learned and made promises to a ceiling he would later learn to call a sky. "Let's make this quick," Judge Granger said now, flipping open a folder that had the disconcerting lightness of a human story summarized. "I've got a golf game at 2. Laughter again, a louder ripple. It landed differently, edging mean. The bailiff's face didn't change, but his eyes did something tired. The reporter's fingers moved unaffected, the way they do when a pianist plays scales as muscle memory, as if they belonged to another person. The gallery smiled and someone whispered. Kylen's mouth did a small thing, a twitch that might have been a smirk if you were inclined to find arrogance in children. In truth, it was only recognition. The judge had just made his first mistake, and most of the room, including the judge, had missed it. Not a legal mistake, a human one. He had confessed his priorities on the record. A game at 2. Justice between breakfast and tea time. Carruthers rose with choreography that promised he practiced rising as much as speaking. His polished shoes clicked smartly as he took exactly 3 steps toward the jury box, positioning himself so the cut of his suit could do supporting work. He did not glance at Kylen. That would have advertised an opponent. He spoke to the room as if reading from a template adapted deftly to the details. "Your Honor," he said, "the state will prove beyond a reasonable doubt that the defendant, Kylen Dalton, was caught red-handed in a stolen vehicle." He let red-handed linger like a known door. A 2022 Audi A6. Reported missing hours before his arrest. Officers pursued the vehicle through downtown Brookmere. The defendant attempted to flee before being apprehended. His fingerprints were found on the steering wheel. He looked down at his legal pad, more for effect than reference, and back up. The evidence speaks for itself. The words landed with the authority of a format. A few jurors shifted. In courtrooms, the shape of a narrative often matters more than its specific contents. People recognize the bones and assume the flesh must fit. Stolen car. Just running. Fingerprints. If you squinted with common sense, as people like to say when they meant, "Don't make me complicate this," it looked complete. Judge Granger tilted a look at Kylen over his glasses that managed to be both brief and whole. Then the judge looked back at Carruthers and said, "Go on," as if pressing a button. "The defense," Carruthers continued, "may try to persuade you this was a misunderstanding, that Mr. Dalton is an unfortunate victim of circumstance." He turned then and finally let his eyes meet Kylen's, calibrated cool. "But what kind of victim runs from police?" The room tightened as if someone had pulled a drawstring. People like to think they are immune to suggestion, but phrasing invites them to a destination without telling them they've been invited. Victim. Runs. Police. A little triad that plays whenever you shake the snow globe that contains American ideas of order. "The state will call Officer David Rios," Carruthers said, shuffling a stack and allowing the paper's rustle to participate in the show. He personally witnessed the defendant behind the wheel. The car was confirmed stolen. The arrest was by the book. "Sounds straightforward to me," Judge Granger said, exhaling through his nose. Straightforward is the cousin of obvious, which is the sworn enemy of careful. Kylen knew better. He had learned to let the room talk itself into wanting a particular shape and then to put just enough weight on one side that the shape wouldn't stand without help from facts. "Defense?" the judge asked, tapping his gavel not so much as a tool of order but as a pencil that wanted to draw a line underneath something. At Kylen's left, a public defender named Marla Torres rose, nerves making the hem of her jacket sway. She had said 3 careful words since entering the courtroom. She was new enough to still carry hope and old enough to know how rooms like this can punish hope. Kylen touched her sleeve and gave a small, respectful shake of his head. Her eyes asked a question. He answered with a look that said, "Thank you. Let me." "I'll be representing myself, Your Honor," Kylen said. Silence, the real kind, dropped into the room with the weight of an object. Even the reporter's keys seemed to wait. The judge's eyebrows climbed 1 notch. Carruthers' smile twitched into something between amusement and annoyance. He released a soft laugh the way you might flick lint from a lapel. "You'll what?" Judge Granger asked, though he had heard him correctly. "I'll be defending myself," Kylen repeated, tone even, hands still in his pockets. "The 6th Amendment gives you that right," Granger said, with the weary crispness of someone reciting a caution he knows will be ignored. "It is a poor idea, frequently exercised poorly. I need to canvass you." He did. That Kylen understood he would be held to the same rules as an attorney, that the court would not act as his coach, that missteps would be his to own, that he had the option of counsel. "Miss Torres will remain as standby." "I understand," Kylen said. He meant it and not defiantly. He had sat in rooms like this long enough to know that respect isn't weakness. It's insulation against the judge's impatience. "Very well," the judge said, and the air moved again as if someone had opened a vent. "Proceed." Kylen let the quiet unfurl just enough to gather attention without turning it into spectacle. Then he turned slightly toward the state's table. "Before I begin, Your Honor, I'd like to confirm something with the prosecution." He gave Carruthers the courtesy of a cue. "You said Officer David Rios personally saw me behind the wheel prior to my arrest?" "That's right," Carruthers said, already bored with what he assumed was posturing. And that assertion appears in his report. Yes, Carruthers said, slightly sharper. He did not like being asked to nod to his own claims in small steps. Kylen turned to the bench. Your Honor, I move to bar any testimony asserting personal observation pending verification. On what grounds? The judge asked, the not-quite smile tugging at one corner of his mouth. Foundation, Kylen said. Officer Rios did not see me in that car. In fact, he wasn't on duty when the chase began. He felt the microshock move through the gallery, people who didn't know they were invested suddenly leaning forward. Carruthers' expression flickered through surprise toward irritation. What are you talking about? He asked, with the tone of a man who believes questions from 19-year-olds should come with permission slips. If permitted, Kylen said, I request production of the department's AVL/GPS logs for Officer Rios's unit for 1930 to 2010 hours that evening, pursuant to Brookmere PD Policy 4.12 on vehicle telemetry retention and access. The state relies on his report's assertion. The telemetry will corroborate or impeach. I have reason to believe it will not corroborate. Policy numbers do a specific thing to judges. They make decisions feel like compliance rather than choice. Judge Granger looked at Carruthers. Counsel? Carruthers cleared his throat. Your Honor, that report was filed by an officer. If the officer was where he claims, Kylen said softly, the logs will prove it. The pause that followed was exactly long enough to be noticed by anyone who knew to watch for pauses. The jurors didn't know they knew, they saw it anyway. The court reporter's fingers slowed half a beat before resuming. The bailiff's gaze moved from the judge to the prosecutor like a weather vane reading a wind change. Any objection to producing the telemetry? The judge asked. Carruthers' jaw moved. No objection, he said, because objecting would have cost more authority than compliance. A small shift ran through the room, like a building settling after a minor tremor. The laughter was gone. The expectations had ducked behind something taller. While the court set the subpoena in motion, Carruthers reached for the old cornerstone. While we wait, he said, the fact remains, the defendant's fingerprints were found on the steering wheel. That's true, Kylen said as if discussing weather. Let's talk about what that means. He faced the jurors and let his voice find the range between conversational and careful. The state is asking you to equate a fingerprint with theft. That's the jump they want. But imagine you walk into a department store and try on a jacket. You slide your hands into the pockets. Maybe zip it up. You put it back and leave. Later, someone steals that jacket. Do your fingerprints make you the thief? Two jurors looked down into their laps, then up again. One, an older woman with teacher energy, tilted her head and made a face that read, "Ha." Someone in the gallery muttered. Someone next to them hushed them. The Audi sat outside a Quick Mart for a while the afternoon before the alleged theft, Kylen continued. I walked by with 3 friends. I leaned against it. The door was unlocked. I opened it. That was dumb. I didn't drive it. I didn't take it. I didn't rummage through it. Curiosity leaves fingerprints. So does theft. The print can't tell you which. He pivoted toward the bench. Your Honor, was the latent print analyst subpoenaed to testify? Judge Granger glanced at the state. Carruthers hesitated a fraction too long and then said, No, Your Honor. The state is prepared to proceed on the report. So the state intends to rely on forensic conclusions without the opportunity for cross-examination? Kylen asked, not snide, genuinely clarifying. No questions about collection technique, no chain of custody foundation, no ability to ask whether the lift was partial or smudged or collected from a surface touched by multiple people? Carruthers' jaw flattened. Reports are neat, witnesses are variables. He preferred neat. Subpoena the analyst, Judge Granger said, pinching the bridge of his nose. The gesture carried a lifetime of headaches and a morning's worth of new ones. Kylen nodded slightly. Respectfully. He wasn't done. Your Honor, I also move to admit a statement by the vehicle's registered owner, Mr. Reginald Whitman, taken the night the car was reported stolen. It is included in discovery but was not emphasized in the state's filings. It bears on identity. It's admissible as a present-sense impression under Rule 803(1). He held up a paper, and the court reporter raised her eyes to catch it with the ears. Mr. Whitman told officers, quote, I left my car running when I ran inside the gas station. Some kid must have jumped in and taken off. But it wasn't the guy you arrested. I saw the kid and he was white. End quote. The sound that followed was that specific courtroom sound that happens when a fact lands and everyone pretends they didn't just feel the floor move. Not quite a gasp, more like a simultaneous inhalation disguised as shuffle and cough. Kylen kept his face still and his hands steady. He offered the paper for the judge's look and the reporter's capture. He didn't look at the jury yet. He didn't need to, the sentence was looking at them. Your Honor, Carruthers said quickly, irrelevant. The defendant was found in possession. I wasn't, Kylen said, tone flat as a scale reading a number. I was arrested several blocks from where the vehicle was abandoned, walking home with snacks. I wasn't in the car. I wasn't near it. I wasn't running from anything. The only things tying me here are a print my curiosity left, a narrative an officer's memory preferred over his location, and assumptions that do the rest. Silence returned, this time with purpose. The judge looked at Kylen for a long moment that acknowledged, without saying so, that the boy had just rewritten the room's assignment. He looked at Carruthers. He looked at the paper. His fingers had stopped drumming. Does the state have anything further at this time? Judge Granger asked. Carruthers's face flushed a precise red that suggested his blood obeyed schedules. No, Your Honor, he said. Judge Granger leaned back, and the chair no longer looked like a throne so much as furniture. The smirk left his mouth and didn't come back. We'll proceed as ordered, he said. Subpoena the analyst. Produce the telemetry. We'll reconvene. He struck the gavel lightly, and the sound was not final but instructive, like the soft click that says we're not done, but the axis has shifted. When court adjourned, the air let go of the stiffness it had held like a breath. People stood, chairs scraped, and the courthouse's acoustic signature changed from orchestral to hallway. Kylen didn't move right away. He knew not to rush after winning a moment. You stand in it and let the dust decide where it will settle. He turned at last. At the end of the aisle, the bailiff watched him with an expression that mixed something like pride with something like worry. At the back, a young reporter with hair fixed to defy humidity glanced at him, then at her notebook, then away as if building a story out of permission and caution. On the steps outside, the weather had elected to be bright but cold, the kind of day that looks like a postcard until you breathe. Reporters gathered like crows, their microphones extended like learning tools. Mr. Dalton, did you expect? How does it feel? What will you do if? The questions layered over one another until they turned into white noise. He pulled his hoodie up, not as a shield from the cameras but because he was 19 and cold and because hoods are habit as much as clothing. He threaded through the cluster without making eye contact. Spectacle wasn't the work. The work was the three pillars he'd erected: telemetry, forensics, owner's description, and the way they might together force a judge to confront the distance between straightforward and true. At the bottom of the steps, Darlene Dalton stood with her arms folded as if she were keeping herself from shaking him, or from crying, or both. She let her eyes scan his face like a barcode that confirmed he was intact. After a long beat she blew out a breath. Boy, she said, voice low so it wouldn't belong to the crowd, you scared me half to death. Had to take a risk, Ma, he said, scratching the back of his head because the body insists on acting young when your mother is looking at you that way. You always were the stubborn one, she said, then pulled him into a hug that smelled like citrus cleaner and paper and home. He let himself fit inside it like he had when he was 8 and didn't know what Rule 803 meant. Across the street, Judge Warren Granger stood by a sedan that had acquired a parking ticket while he was on the bench. His posture no longer wore arrogance as a jacket. In its place hung something like reflection. He hadn't expected to remember this case. He had assumed it would become the day's familiar satisfaction, the small relief of watching a system do what it always does. Instead, a boy with a policy number in his mouth had held up a mirror. The judge put his hands in his pockets and watched the boy with the hood and the woman with the folded arms and looked, for a moment, like a person rather than a role. Kylen met his eyes just briefly, then turned away. The steps down felt like steps toward something rather than away from something. He didn't know how long the path would be. He knew which way it went. He moved into the cold, cameras pecking at the edges of his attention. Behind him, the courthouse hummed with new cases and old habits. Inside him, the pillars stood. Telemetry. Forensics. A sentence an owner had said into air that finally decided to carry it. He didn't know the ending yet. He didn't need to. He had the next scene. He had learned a third thing about courtrooms too. Sometimes the room laughs at you before you speak and sometimes it listens after. If you are lucky or prepared or both, the listening lasts longer. And sometimes even it changes something. The apartment wore the afternoon like a thin sweater, stretched over too many shapes, pilled in the places that worked hardest. A radiator clanked without rhythm, trying and failing to remember how to be a drum. Outside, Brookmere's buses sighed at the corner, kneeling for passengers and rising again with the offended dignity of old machines. Inside, the kitchen table had been annexed by a banker's box stamped with the courthouse crest and the word Discovery in a font that pretended neutrality. Darlene Dalton slid the box onto the table with the kind of care usually reserved for cake. "All of it," she said, catching her breath. "Or all they think we'll notice." Kylen peeled the lid off. Paper breathed up. The smell was familiar. Copier toner, manila, the faint antiseptic of bureaucracy. He felt the weight before he counted it. "Index first," he said, reaching for the cover sheet because that's what his mother had taught him. Law rewards people who admire the table of contents. A stapled packet listed items in tidy bullets: incident report, supplemental narratives, arrest affidavit, dispatch CD printout, property and impound logs, latent print report, evidence room ledger, 12 photographs, a USB thumb drive sealed in plastic, witness statements 2, owner statement 1. He checked the boxes. Owner statement included, he said. They didn't hide it. They just didn't want it to be invited to the microphone. Darlene snorted and poured coffee. "Hiding takes work," she said. "Neglect is free." He pulled the first report. Officer David Rios's narrative led with the shape he already knew. Call for a suspicious vehicle weaving near the Quickmart. Patrol units respond. Audi A6 located abandoned on Pierce and 11th. Defendant found in vicinity moving away from scene at a hurried pace. Arrest following brief non-compliance. Rios listed personal observation of defendant operating vehicle in a sentence that read like it had been cut and pasted from a different night. Kylen laid the report beside the CAD log. He traced his finger down timestamps half a step out of tune. 1931, first 911 call. 1933, dispatch assigns units. 1947, civilian reports Audi turning off Pierce. 1954, Unit 21 confirms abandoned vehicle. 1956, Rios marks on scene. The word observed in Rios's narrative glowed like a misprint. He wasn't there when the weaving happened, Kylen said. Telemetry will kill, observed, dead. Darlene slid the Brookmere PD policy binder across the table. 4.12, she said. Retention 90 days. Access via supervisor or court order. AVL records by unit. They hate pulling it because it makes lines solid. She tapped the retention line. You've got time, but not the kind you can waste. He read the policy anyway, lips moving on the parts with numbers. It wasn't that he didn't trust his mother. It was that reading a thing makes it yours. We ask for 1930 to 2010, he said, already writing the range on a yellow pad. Tight window. Looks reasonable. Looks like you know what you're asking for, Darlene said. Judges like requests with edges. He opened the latent print packet. 32 pages performed the ritual of certainty. Lab header, accreditation seal, method statement, photographs, chain of custody stamps. Squeezed between boilerplate, a few skinny facts tried not to drown. Item 3, steering wheel. Lifted latent impressions. 1-1, suitable for comparison. The analyst described a partial right thumb pattern matched to Kylen's booking prints, to a reasonable degree of scientific certainty, the phrase that makes defense attorneys itch. He turned to the photos. The wheel, a glossy circle with dust sitting on it like chalk on a gymnast's hands. The lift card, black ridges hooked like tiny fish bones. On the envelope flap, a marker scrawl, Harlan with a time and date. Down on the property log, a second name appeared, Jeffers, unmoored from narrative. 2 collectors, Kylen said. Harlan and Jeffers. But only Harlan writes a report. They split scenes when they're tired, Darlene said. Or when the coffee is behind them instead of in front. He traced the chain of custody left to right like a commuter diagram. 2111, collection at scene, Harlan. 2204, vehicle impounded. 2257, evidence room accepted item 3. 730, lab received. Between 2111 and 2257 there was a gap fat enough to hide a sandwich and a mistake. Where was the envelope for 53 minutes? He asked. He didn't need an answer yet. He needed the question to grow. He flipped to the owner statement. The font changed. The paper had the crinkle of pen pressed hard. Reginald Whitman, contractor, white male, 56, who had left his car running to get a coffee, just in and out. The sentences were hurried as if they feared they would evaporate. Some kid jumped in and took off. Not the one they arrested. I saw the kid, white. Kylen read it twice, then let the page rest under his palm until it warmed. They'll argue he was shaken, Darlene said. Memory under adrenaline. Lighting. Angle. All the classics. He said it twice, Kylen replied, pointing to a second line where Whitman had repeated, white kid, after the officer asked, you sure? And the clerk heard something like it. You have a number for the clerk? He flipped the index. Witness statements, 2. He tugged them out. One from a woman named Shanice Davis, afternoon shift at Quick Mart. Owner ran in upset. Said gone. Said left it running. Said kid was white. The second from a man who had been at Pump 6 and heard shouting but saw nothing useful. Kylen wrote Shanice, 8031, on the pad and underlined it. Present sense impression. He loved rules with parentheses. They felt like secret doors and sentences. The USB drive had been sealed with evidence tape that pretended to be serious and failed. He cut it and opened the files. Photos, door panel, center console, steering wheel, the Audi sleeping in an impound lot under fluorescent indifference. One video clip, an impound walk-around, shaky and boring until a frame showed the passenger door unlocked. Someone tried it and it opened with a shrug. Kylen paused and rewound. Unlocked, he said. And in the photo at the Quick Mart, the door looks shut but not latched. He pinched to zoom and saw a sliver of black where metal should kiss rubber. Don't oversell, Darlene said. Juries resent magic. They like kitchen work. It's all kitchen work, he said, gesturing at the table. They ate standing up, bowls in their hands because the case had taken their chairs hostage. After Darlene wiped the counter the way she wiped ideas. Small circles, pressure, patience. You didn't tell me, she said quietly, that you were going to represent yourself. I didn't know, he said. I felt the room and then I knew. If I waited, I'd be playing somebody else's tempo. You understand there's a version of today where a judge says no and you learn humility the hard way. I brought him a policy number, Kylen said. Humbled him gently. She hid her smile in the dish towel. Make the motions. Don't be clever. Be precise. He sat with the yellow pad angled just so and wrote pillars at the top like a headline for himself. Under it, telemetry, Rios policy 4.12. Forensics, analyst plus chain gap. Owner description, Whitman plus Shanice, 8031. Flight? He circled the last word. You didn't run, Darlene said, reading over his shoulder. No judgment in the voice, just inventory. I walked fast, he said. It was cold and sirens make you move. They will still call it flight. See it before they say it. Answer it before they ask? Ask it before they answer, she corrected. Take their favorite toys and explain why they squeak. He drafted the motion to compel production of AVL/GPS data with handwriting that had been scolded into legibility by a fourth-grade teacher who believed in ink and consequences. He wrote like a person the clerk would not sigh about. Defendant respectfully moves this court to order production of AVL/GPS records for Unit 21, Officer David Rios, from 1930 to 2010 hours on date. He quoted Policy 4.12, its retention period, its access clause. He explained why observed must submit to coordinates. He kept it under 2 pages because judges appreciate mercy even when they don't notice it. Cite State versus Holcomb, Darlene suggested, flipping a binder. Our appellate court on objective data impeaching narrative. Not exactly this, but close enough to sound like family. He added a parenthetical. See also in the case cite. He didn't love writing like a person who wore a tie, but he loved how it made the paper feel heavier. He texted 3 friends who'd been with him at the Quick Mart. Need your statements. Truth and boring. 2 replied quick, bet and say when. The third sent do I gotta wear a tie and then JK I'll be there. He smiled and felt briefly 19. The clock grabbed hours and hid them. At 9 their neighbor knocked to borrow sugar and left with a cup and a story. At 10, the radiator exhaled a rattle that sounded like a jury deliberating. At 11, Darlene brought out their small notary stamp and swore in the two friends who'd arrived in their best jeans, solemn as ushers. They swore on nothing but their names and her steady gaze. They told the same version in different words. We walked by, Kylen opened the door, we told him bro stop. He laughed, we went inside, later sirens. She notarized. They left with relief like steam rising off them. Find Jeffers, Darlene said when the door clicked shut. If he exists, the chain of custody owes him a line. Kylen combed the supplemental logs until Jeffers reappeared as a signature on his scene security sheet and nowhere else. He wrote subpoena? And drew a box around it. You can learn a lot from who doesn't write reports. His phone dinged. An email from an address at the prosecutor's office. Subject line, plea offer, Dalton. He opened it and read the flat generosity. State is willing to amend to criminal trespass, misdemeanor, with time served and costs. Offer open until Friday 5 p.m. He felt the tug. A lifeline tied to a rope that drags as much as it rescues. He turned the screen to Darlene. They're managing their calendar, she said. Don't make it moral if it's math. What would you tell your client? He asked. I'd put the risks on the table, she said. The judge could wake up on the wrong side of his robe. The analyst could be a star. The jury could decide prints are magic. I tell my client to choose the version of sleep they can stand. He looked at the pillars. I want my telemetry, he said. It came out quiet and stubborn. Then we fetch it, she said, equal parts pride and worry. He filed the motion at the clerk's window on the first floor of the courthouse, a place that always felt like the inside of a filing cabinet. The clerk stamped with the rhythm of a heart murmur and slid copies back without looking up. Hearing Friday, she said, pointing at a docket list with a gnawed pencil. The pencil had been biting back. He walked out onto the courthouse steps with the motion in a folder, and for a second he imagined the paper as a small origami boat you could set afloat on a stream that knew where to go. Then he remembered streams need gravity. He would be that. Back at the table, he wrote his short memo to go with the motion. 3 bullet points, 1 sentence each. Relevance, AVL/GPS data bears directly on veracity of observed claim. Availability, policy mandates retention. Narrow window minimizes burden. Prejudice, denial would impair defendant's ability to impeach central narrative. He printed it and placed it on the left side of the box. Left was filed or ready. Right was to be hunted. He flipped to the analyst's CV attached to the lab report. Dr. K. H. Patel, Latent Print Examiner 2, AFIS certification, 12 years. He didn't feel like picking a fight with a person who had earned hard letters. Good cross, he reminded himself, is respect with a scalpel. He made a new page, Patel, cross, and divided it into 3 columns. Foundation, who collected, who sealed, who transported. Method, quality, partial, substrate, contamination risk. Limits, can't data print, can't tell behavior, can't assign intent. Tone, Darlene said from the sink. Respectful, he answered without looking up. Curious, not cornering. Jurors punish kids who peacock. They punish adults who peacock too, she said. But adults get away with it more. He stared at the chain of custody log until the numbers flirted with nonsense. He stood to refill his coffee and caught his reflection in the kettle, warped and a little older. He wondered how many kids came home from court to this. A mother who could say Rule 803 like it was a recipe, a table that could hold a case, a radiator that sang worry songs. He wondered how many came home to nothing but a charging cable and a bed that didn't sleep back. He wrote voir dire on a fresh page and listed questions that sounded honest instead of clever. Has anyone tried on a jacket at a store and put it back? How many of you have left a car idling to just run in? Can a fingerprint tell you when it arrived? Do we expect police reports to be accurate always, or almost always, or usually? He underlined always and wrote trap beside it. Don't make people choose between the law and their uncle who's a cop. He slept late, as in 1 a.m., on the couch because the table had claimed the rest of the apartment as a client. He dreamed in timetables and woke twice to text himself things he didn't trust morning to remember. Ask about Jeffers's gloves and telemetry is a witness that can't lie but can be read wrong and don't sound proud. Morning delivered a reply to his no, thanks on the plea. A clipped offer stands until Friday with no emoji and no judgment, which is a kind of judgment. He brushed his teeth with the taste of printer dust still in his mouth and put on the collared shirt from yesterday because it had already learned the day's shape. The hearing on his motion to compel happened in a courtroom that smelled like the one from yesterday, as if courtrooms all share a supply of air that circulates between them. Judge Granger took the bench, gavel as baton. Motion to compel AVL/GPS production, he read, almost bored. Mr. Dalton? Kylen stood. Brookmere PD Policy 4.12 requires retention of vehicle telemetry for 90 days and permits access by court order, he said, the words finding their groove. The state's narrative relies on Officer Rios's personal observation, which the telemetry can corroborate or impeach. We request a narrow window, 1930 to 2010. The burden is minimal, the value is central. State. Granger asked, turning. Assistant District Attorney Miles Carruthers rose with a face that tried not to show annoyance. Your Honor, the defense is fishing. With a policy-mandated net, Kylen said, not smiling. Granger's eyes dropped to the site on the motion, lingered on the highlight over 90 days, then came back up. Order granted, he said. Production within 7 days. Coordinate with counsel. The gavel tapped, small and decisive. The gallery shifted but did not care. No one claps for foundations. Kylen didn't grin. He wrote granted on his pad with controlled handwriting and sat down. On the way out, a reporter he recognized from yesterday matched his pace with small steps. Mr. Dalton, she said, and her voice had the politeness of someone asking a dog if it bites. Is telemetry common in cases like this? It's common in police cars, he said. Not that common in courtrooms. Can I quote you? You just did, he said. Darlene appeared at his elbow the way weather does and steered him down the hall. On the curb they ate bagels off napkins. Darlene chewed like a person trying to make bread into sleep. You speak judge, she said. I speak numbers, he answered. Judges translate if they like the font. Don't get cute, she warned, then softened. You did good. He called the quick mart during Shanice's shift. She remembered his voice and not his name. The guy with the Audi came back yesterday, she said. Bought coffee. Told me he's getting a spare fob so the car locks itself if he forgets. That's a good policy, he said, and heard his mother snort in the background. You going to need me to come in? She asked. I can get my cousin to cover. Yes, he said. I want the words you heard. Not an opinion. Just your ears. I can do that, she said. Been doing that my whole life. He added Shanice, subpoena to the to-be-hunted side. He drafted a simple witness list and filed it. He drafted a proposed order for the telemetry because judges are like restaurants. They move faster when you hand them a menu. He handed it to the clerk with the same alert handwriting. The clerk stamped it without seeing him. He accepted the anonymity because the paper had his name. That night, he practiced saying Your Honor without impatience and Dr. Patel without awe. Darlene sat in the doorway like a ghost of all the exhausted paralegals who had ever watched a kid try to lift something heavy. Ask Dr. Patel if the lift card was sealed with evidence tape at the scene or later, she said. Ask if the lab uses blind verification. Ask who signed the envelope seam. He added the questions to the cross columns. He practiced them aloud until the radiator stopped clanking so it could listen. Near midnight, he felt a wobble rise in his chest. The kind you name anxiety because it's not quite fear. He let it be a guess. What if the telemetry comes back muddy? He asked the room. Then you cross on what it does say, Darlene answered without looking up from her binder. Miles can try to sell fog. You sell the lamp. And if the analyst is excellent? You respect her, she said. And you make the jury love the limits of her excellence. He laughed, a small tired sound. I wish it were enough to be right. It rarely is, she said. But it helps not to be wrong. He set 3 alarms because he didn't trust the morning. He closed the box and rested both hands on the lid for a second, the way people do at coffins and at boats. Then he slid the box under the table as if the case could sleep too. He dreamed of a steering wheel that turned under his hand and of a voice saying white kid like it wanted someone to catch it in midair and put it somewhere safe. He woke before dawn to the sound of the first bus at the corner and the knowledge that some things will never belong to you until you ask the right way. He looked at the pad where pillars sat at the top like a blessing and a dare. He put the coffee on and pulled the box back up. Day 2 in a fight is where you decide whether yesterday was luck. He sharpened a pencil with a knife. It felt good to make a point. The clerk's office lived behind glass that had given up on pretending to be clean. Everything looked slightly smudged, as if the building itself had been fingerprinted. Kylen stood at the counter with his motion to compel telemetry, the memo clipped behind it, and the proposed order tucked like a polite suggestion. A woman with a nameplate that read Mrs. Hollis stamped each document with a sound that could have been a heartbeat if you believed in bureaucratic romance. "Filed," she said, sliding his copies back under the pane. "Judge Granger's calendar Friday at 9 for argument. Don't be late, he's allergic." "Thank you," Kylen said. He meant it. Courtesy had always felt to him like a tool you could keep sharpening without shortening it. He stepped out into Brookmere's late morning cold. The courthouse plaza had a small fountain that never worked in winter and sometimes didn't bother in summer. Pigeons strutted like junior partners, fussy, entitled, faintly ridiculous. On the far side of the square, two public defenders passed a cigarette between them and a laugh between that, and he watched their shoulders sag and rise as if the smoke were part of the work. He checked his watch. He had promised himself 1 hour in the courtroom, not his courtroom, any courtroom, to watch the machinery he'd be putting his hand into. He slipped into Division B, where arraignments moved like a conveyor belt that had learned to talk. The air smelled like coffee that had been abandoned and was thinking about forgiving you. The judge in B was not Granger. Judge Phelps today, compact and brisk, a man who looked like he ironed his own shirts and did it well. He processed a line of defendants with a speed that wasn't cruelty so much as survival. "Name? Do you understand the charge? Rights? Plea." He repeated the warnings until they sounded like a prayer he no longer believed in but still said out of habit. The public defenders whispered to clients whose eyes slid anywhere but the bench. The prosecutors offered deals with the cadence of a lunch special. The clerks typed through it all, soundtrack and metronome. Kylen took a seat in the back and watched the choreography, the way a prosecutor learned to angle his body toward a jury even when there was no jury, the way a PD learned to lean an inch closer than comfort to reach a client in a storm of sound, the way a bailiff's eyebrow could stop a man from standing at the wrong time. He watched the language too. Time served, probation, no contest, phrases that anesthetized outcomes large enough to tilt a life. He wasn't pretending he was above it. He knew from his mother's stories how much mercy traveled under the lumpen grammar of pleas, rent paid, jobs kept, children fed. But he also knew that speed can become a value and then a belief and then a religion. And religions, he had learned, are efficient at excusing themselves. He took notes on the back of his copy of Policy 4.12, because he liked the idea of writing observation notes on a rule about observation. He wrote, "Phelps interrupts when he smells speechifying, keep it short." He wrote, "Clerks perk up when lawyers bring proposed orders, keep doing it." He wrote, "The room forgives mistakes if you confess them before someone else does." A PD he recognized, Jerome, the legal aid lawyer he'd shadow soon enough, caught his eye on the way out and lifted 2 fingers in a greeting that was half salute, half "we're all trying." Kylen lifted 2 back. Back on the courthouse steps, he called Darlene. "Hearing Friday. Division A, 9 sharp. Phelps in B is a symphony of impatience." "You're mixing metaphors again," she said. He could hear office printers and the low thrum of other people's lives on her end. "Granger will be punctilious. Bring a copy of the policy and a copy of your own motion even though they have it. Judges like to have something to hold so they don't hold your throat." He laughed. "Copy that. Do not make jokes like that in the courthouse," she said, and then he heard her smile. "What's your plan this afternoon?" "Draft a short for the confrontation issue," he said. "I want to lock in that the analyst has to show. Keep it clean. Cite Crawford, Melendez-Diaz and our state's Parker case. And remember, you're not doing law review. You're building a step stool for a judge." He put her on speaker and set the phone on the counter while he cleared the kitchen table again. The banker's box had become a roommate, solemn and demanding. He put the chain of custody timeline to one side, the witness statements to the other, the lab report in the center like a reluctant king. He pulled a fresh sheet and wrote at the top, "Memorandum in support of objection to admission of latent print report absent testimony." Then he wrote the thing he wanted to be the only sentence the judge remembered, "Reports don't cross-examine themselves." He knew better than to leave that line naked, so he dressed it. The confrontation clause requires that testimonial evidence be presented by a witness subject to cross-examination. A lab report containing conclusions about identity is testimonial. He built the latter. Crawford for the principal, Melendez-Diaz for the lab report, Bull coming for a surrogate analyst's insufficiency, Parker for state-specific comfort. He wrote a second thing in the margins for himself. Respect Dr. Patel. She's not the enemy. Limits are. He circled it. It helped to make rules on paper when the rules inside him fluttered. The radiator rattled, then unclenched. He poured water into the coffee maker not because he needed more coffee but because writing likes rituals. He thought about Officer Rios and words like observed. He thought about the way a report becomes a story, becomes a sentence, becomes a night in a cell. He thought about his own hand on the Audi's handle, how light the touch had been, how heavy the print felt now. At 2 he walked to the library because librarians respect requests more than judges do, and because there's a kind of quiet there a person can borrow. Brookmere's main branch had been built in an era that believed civic buildings should make you feel small and welcome at the same time. He climbed the stone steps, pushed through the heavy door, and exhaled a breath he didn't know he'd been holding. He moved to the law section, a modest shelf that tried hard. He pulled a slim volume of state evidence rules and flipped to hearsay, tracing his finger down exceptions like a person shopping for a jacket. Present sense impression. Excited utterance. Then existing mental, emotional, or physical condition. He wrote, 8031, Whitman. 8032, maybe if he was shouting. Then he put the book back exactly where it belonged because order is a friend when chaos is your hobby. He took a seat by the window and drafted voir dire in longhand. He'd do the boring questions everyone does because you have to. Presumption of innocence, burden on the state, can you follow the judge's instructions? But he wanted to get to the ones that changed the air. He printed each on its own line. Has anyone here ever touched something they didn't own? Out of curiosity, not malice? If you leave a car running to run inside, do you expect a stranger to make a choice for you? Does a fingerprint tell you when it arrived? Have you ever misremembered a detail and corrected yourself when you saw a receipt or a text message? Telemetry by analogy. Can you imagine a world where an officer writes what he believes is true and the data says otherwise? What would you do with that? He pictured asking the last one and felt his stomach step softly to the side. Jurors don't like being asked for imagination that indicts their comfort. But he didn't need them to convict a thought. He only needed them to acquit a boy. On his way out, he stopped by the media lab where a volunteer taught older folks how to email photographs to grandchildren without summoning a demon. The city felt small and true and alive, and he filed that feeling under reasons to try. At home, he found an email from the DA's office confirming a subpoena had been issued to Dr. K. H. Patel. The subject line, subpoena issued, was an all-caps shrug. He replied with a brief received, thank you because he wanted a paper trail in which he always said thank you. He also found a message from an address that resolved to david.rios@brookmerep.gov. Miles Carruthers liked desks that looked like decisions. His at the Brookmere District Attorney's office had room for 3 piles and 1 plant. Any day there were more than 3 piles, he took something home or killed something on the calendar. The plant, an indestructible snake, office culture's answer to hope, had been alive longer than some cases. On the wall, a framed print that said do justice in a font you choose when you need the words to do most of the lifting. Beside it, a photo from law school moot court where he had stood with a team in rented suits and learned that applause is cheaper than outcomes. Wednesday, 8:12 a.m. he opened his email and found the subject line he already disliked. Motion to compel AVL/GPS, Dalton. He had expected it. The kid with the hoodie and the policy number had filed the thing clean and short. 1 page plus a memo that didn't try to write a treatise. Miles read the highlight over retention, 90 days, and felt the familiar irritation that comes when effort will be demanded where habit sufficed last week. Pro-SE defendants, he believed, multiplied effort. They had time for principles, and principles meant hearings, and hearings meant the calendar grew a spine. He forwarded the motion to his supervisor with a 3-word cover, "We'll oppose perfunctorily." The supervisor, Andrea Lowen, replied from down the hall with a thumbs-up emoji and then, because she preferred words to pictures when it counted, stepped into his doorway a minute later. "Is this the kid?" she asked, leaning on the frame. Andrea had the tired competence of someone who'd been promoted so often she couldn't remember what she had loved before the promoting. "Dalton," Miles said. 19. Pro-SE telemetry kid. "Telemetry kid," she repeated, smiling despite herself. "He made Granger order production?" "Friday hearing," Miles said. "He'll try to make it sound like he's showing us our own map." Andrea's smile flattened. "Fine. Ask BPD to pull it. If it helps, great. If it hurts, offer him the misdemeanor and move on. She lowered her voice. Watch the press. A reporter sniffing around the teenager schools the state angle. No hero arcs that end at our expense. He nodded and turned to his screen, already drafting the opposition, which he kept short and sullen because the point was to look offended by the idea of fishing, not to pretend there were no fish. When he finished, he opened the Dalton file. He had built it like he builds all files. A fact sheet stapled to the inside cover, charges in block letters, witness list with phone numbers, a timeline that looked more like a promise than a plan. Facts as sold by the report. Audi A6 stolen near Quickmart around 1935. Officer Rios observed defendant operating vehicle. Narrative line. Vehicle ditched on Pearson 11th around 1950. Defendant detained at 2003, 3 blocks east, moving away at hurried pace. Latent print on steering wheel matched to defendant's right thumb, partial sufficient. Owner, left car running, white kid included in discovery not helpful. His eyes snagged on white kid. He had highlighted it early and then convinced himself highlighting was morally sufficient. He told himself you don't have to introduce the part of the story that hurts your story, the defense will do it, and then you'll say things about lighting and adrenaline and angle and distance. He had said those things before. They were sometimes true. He stared at the words anyway and felt the tiny itch of a conscience that hadn't been sanded all the way down by docket pressure. He called Officer David Rios. Rios answered on the third ring with the tone of a person surprised to be spoken to before lunch. "88 Carruthers," Miles said. "Got a minute on Dalton?" "Sure," Rios said, cautious. "Your narrative says you observed the defendant operating the Audi," Miles said. "Telemetry's been requested. I need to understand what 'observed' means in your sentence." A pause that sounded like Rios looking for a better version of the truth. "We got the call," Rios said. "Audi weaving. I'm en route. Another unit finds it ditched. I'm canvassing. I see the kid walking quick. Hoodie jeans. Dispatch said black male in hoodie. He matches. We stop him. He talks fast. Hands smell like wool dust to me. Prints later." "So you didn't see him driving?" Miles said. "I saw him walking away," Rios said. "Which is what people do when they stop driving a stolen car." "Different verbs," Miles said, and he kept his voice flat because Rios's reaction mattered more than his own need to feel superior. "Telemetry will show your car not on scene until 56 after the hour, if the CAD log isn't lying. Your reports, observed, can't mean driving." Rios exhaled through his nose. "We write observed a lot," he said. "It's the word you learn. It covers more than eyes." "It shouldn't," Miles said, and then wished he'd said it as a suggestion and not a rule. "Okay. On the stand, avoid that word. Arrived and canvassed will keep us out of crossfire." "I can say what I did," Rios said, tone cooling. "Good," Miles said, and decided to stop there. He hung up and typed a note. Rios, narrative loose on observed, prep to avoid flight, use moving away. He emailed the lab supervisor to confirm the availability of Dr. K. H. Patel. The lab responded with a boilerplate. Analyst available Friday. Subpoena required for trial appearance. He sent the subpoena request to the clerk with the speed of someone doing an unpleasant chore before he could be tempted to forget. He preferred trials with reports and no people because paper didn't sweat. But if the kid wanted the confrontation clause recital, Miles would sing along. At 10:30 he walked to Andrea's office for the weekly numbers meeting. The whiteboard listed each ADA by initials and the tallies that kept the building's lights on. Filed, pled, tried, dismissed, reset. Andrea capped a marker with her teeth and wrote +3 next to TM for trespass please. When she reached MC, she looked at him, eyebrows politely up. "Offer out on Dalton," he said. "Trespass time served. He'll probably say no. Because he's 19 and the righteous always say no until they need to say yes," Andrea said. "How's the case?" "Fingerprint on wheel," he said. "Partial but sufficient. Chain has a gap we can paper over. AVL will hurt our observed line. Owner's description cuts against us." "Then don't emphasize a thing that cuts you," Andrea said. "We aren't in church." She kept writing. "If AVL is ugly, offer him disorderly conduct. If he still wants to be Atticus, we try it and let a jury have their fun." "I'll keep it in trespass," he said. It's fairer than disorderly. Andrea looked at him in the way supervisors look when they hear the word fair in a building where the metric is final. You do what keeps the docket moving and your conscience sleeping, she said. Preferably both. He ate at his desk, 2 protein bars and the part of an apple that wasn't bruised, while highlighting the lab report's few useful sentences. He knew how to sell prints without overselling. Lean on the expert's training, let the jurors decide whether machines and magnifiers earn their salaries, remind everyone that criminals touch things when they steal them, which is almost as good as prints don't lie, without inviting a cross-examined exception. He drafted his opening in bullet points because he distrusted paragraphs that promised too much. Stolen Audi. Print on wheel. Defendant detained near scene minutes later. Common sense. He wrote don't promise observed. He wrote address white kid, only if forced, lighting/angle stress, not identity with certainty. At 2 o'clock, he drove to the impound lot with a junior investigator because sometimes jurors ask for details you only know if you've smelled the place. The lot sat behind chain link and resignation. A clerk with a bracelet of keys led them past 2 Camrys, a pickup with its front end smushed like a closed fist, and the Audi, an A6 that had once signaled ambition and now said exhibit. Miles opened the driver's door with a gloved hand. The interior smelled like ozone and powder. He imagined a thumb on the wheel, Kylen's or somebody else's, and then immediately unimagined it because he disliked seeing pictures that couldn't be proven. He checked the door locks out of habit. The passenger side had that stubborn give of a door that isn't sealed. He wrote, door likely unlocked, and felt the defense's jacket try-on metaphor arrive uninvited. He closed the door gently as if anything could bruise further. On the way back, the investigator, Ramirez, asked, "You going to call the owner? Reginald Whitman?" Miles said, "If I can avoid it." "You going to pretend he didn't say what he said?" Ramirez asked, not snotty, curious. "I'm going to put on my case," Miles said. "If Dalton wants Whitman's description, he can offer it under 803(1). Then I'll say the thing every prosecutor says about adrenaline and eyes." He kept his eyes on the road. "And I'll hope the jury prefers a print to a glimpse." "Maybe the jury prefers both to a shrug," Ramirez said, and then let the conversation end, which is the kind of generosity you get from people whose job is to watch you pick a path and not trip. Back at his desk, Miles found the AVL production email from BPD. He opened the attached map and watched the blue line move, Precinct, Pierce, Portman and 8th. No dot near the quick mart when the call came in. Observed sat on the screen like a word that had decided to retire. He felt something he had learned to file under inconvenient. He could try to argue the timeline was noisy. He could try to sell the difference between didn't see driving and saw near car. He could, if pressed, sigh and downplay. He added a new line to his opening notes. We don't need observed. We need proximity plus print. He could do that. At 4:15, Andrea poked her head in again. How's our young Thurgood? Filed clean motions. Telemetry hurts, observed. The lab's fine. Chain gap is 53 minutes. I'll have to prep the analyst to talk about seals like they're chastity belts. Andrea groaned. Don't say that in front of a jury. Or HR. Noted, he said. Offer stands. Good, she said. If he takes it, you've saved me a chalk mark on tried. If he doesn't, do not turn him into a folk hero. Keep your temperature low. When he left the office at 7, the winter light did its short, merciful thing. He drove home to a quiet house. His wife, Leah, a public school counselor, beat him there by an hour and had left him a note on the counter in purple pen. Pasta in the oven. Don't read email while chewing. He smiled and read email while chewing anyway because he was insufferable when a case turned into a mirror. He told her about Dalton over the table while their cat made the rounds like a tiny judge ready to recuse from nothing. Teenager representing himself, he said. Telemetry request. Confrontation clause. Owner says white kid. Leah raised an eyebrow. And is he? White. No. Black kid. The owner's description helps him. No, she said gently. Is he a teenager representing himself because he thinks he's smarter than you, or because he can't afford the version of you people don't joke about? Standby counsel is assigned, Miles said. He wanted to be his own voice. You know I love a young person with a spine, Leah said. I also love prosecutors who remember that the system is not a machine so much as a group project. He laughed, a little resentful and a little relieved. You always make me feel like my posters are lying. Your posters are aspirational, she said, nodding toward due justice in his mind. Aspirations are good when they boss you around. After dinner, he took his laptop to the couch and reviewed voir dire questions. He made a list of things he needed to know from jurors. Do you believe forensic science is infallible? He hoped for no. Do you give more weight to officer testimony by default? He hoped for yes, then would try to temper it without insulting the officers sitting in the back. Have you or someone you know been a victim of auto theft? Always, someone had, and that somebody scowled through the fingerprint portions like they'd been personally smudged. He added a new note he hated: how to address implicit bias without losing half the box. He had learned a thing about juries. If you lecture them about racism, half will bristle and the other half will nod too hard and then forget. If you ask them about perception under stress, most will confess a moment when their own brain played tricks. He wrote, has anyone misidentified someone across a room and then corrected yourself up close? You would use that. He could keep the room from feeling accused while asking it to examine itself. The trick was to keep his own face from showing he knew that was what he was doing. He slept poorly because he always did before court, and because somewhere under the habit of victory was a boy he had been once who had wanted to do something good and large and uncomplicated in a world that insisted on messy. He dreamed that the blue AVL line walked off the map and into the gallery and sat down with a sigh. Thursday morning he prepped Dr. Patel by phone. Doctor, he said, the defense will hit chain of custody and methodological limits. Be transparent and do not overclaim. I never overclaim, Patel said, mildly offended. The report says partial sufficient. The comparison was verified. I cannot date a print. I cannot place a particular thumb at a particular time. Don't say can't too many times, Miles said, then heard himself and winced. Say what you can say and stop. She chuckled. You prosecutors always want poetry until it rhymes with doubt. He smiled despite himself. We're allergic to rhyme that favors the other side. He hung up and dialed Rios to say the thing no prosecutor enjoys saying to an officer: we need to massage the narrative. He chose better words. Let's be exact, he said. Avoid, observed. You arrived, you canvassed, you detained. Let the jury do the math. I like math you do out loud, Rios said, but he didn't push. What about the kid being black and the owner saying white? I'll address lighting, Miles said, if I have to. With any luck, the judge keeps Whitman's words out. You think he will? Rios asked, tone skeptical. Depends on timing and who asks, Miles said. And on whether he ate breakfast. They both laughed at the ritual cheap shot at judicial metabolism. It made the hierarchy feel friendlier, like a family you complain about. At noon, he saw Kylen in the hallway outside Division A, carrying a thin folder and a yellow legal pad like props a TV show gives a teenager to telegraph law. The kid's tie was too short, which made Miles want to fix it, and the idea embarrassed him, so he said, Mr. Dalton, as neutral as he could. Mr. Carruthers, Kylen said, polite and unruffled. He held up a copy of Policy 4.12 because of course he did. Thank you for coordinating with BPD. We're all coordinating with BPD, Miles said and surprised himself by smiling. Offer still on the table. I saw it, Kylen said. The telemetry's more interesting. Miles glanced at the page the way a person glances at a mirror they don't trust. Telemetry's a map, he said. Maps aren't stories. Neither are reports, Kylen said. It wasn't snide. Miles liked that. Good luck tomorrow, Miles said. He meant it, not in the theater sense but in the human one where luck is when a thing happens the way it should and not merely the way you planned. In the afternoon, a reporter called and left a voicemail asking for comment on the rare instance of a pro-SC defendant winning a pretrial motion. He didn't return the call. Andrea sent an email, do not create villains or heroes in the press. He typed Roger and did not click send because he knew she'd just walk to his door and say it again. When she did, he said, I'm not talking to anyone, and she said, good, and they went back to their separate rituals of being the law's hands even when the law felt like mittens. He spent the early evening rewiring his opening to account for the telemetry he could not wish away. He cut the line about observed and wrote, officer arrived minutes after theft, defendant detained 3 blocks away, fingerprint on wheel. He underlined fingerprint 3 times and then erased 2 underlines because jurors don't like being yelled at on paper. He added a sentence he hoped would sound like common sense instead of overreach. People who steal cars often leave traces of themselves in the cars they steal. He would let the analyst do the science and the jurors do the leap. When he finally closed the file, he looked at the DO justice print and said out loud, "I'm trying," because sometimes saying it wakes up the part of you that makes it true. Then he turned off his desk lamp so the plant could sleep and walked to the elevator with the feeling he used to get before finals, prepared enough to know everything he didn't know. Friday opened with cold that made the walk from parking to the courthouse feel like penance. Inside Division A, the room hummed that special courthouse hum. Heels on tile, whispers that wanted to be secrecy, the long exhale of a building bracing to decide. Rios sat in the back in his uniform with his hat in his lap, posture just rigid enough to look like a brochure. Dr. Patel arrived in a navy suit and sensible shoes that telegraphed thrift and the inability to be rattled. Andrea sat in the second row, not because she needed to supervise but because she liked to watch when a story tried to change its genre. Granger came in like weather, predictable, and still you looked up. The clerk called the case. Miles stood and felt the familiar click of roll fitting into person. He could do this. He had done this. He would argue without heat and lose without sulking if he had to. Telemetry production, Granger said, which was last week's song then, analyst subpoena and confrontation clause, which would be today's dance. Miles acknowledged he would call Dr. Patel. Kylen nodded as if he had just approved the menu. Then came voir dire. Miles asked his questions and watched faces like maps. The retired teacher with a mouth that did skepticism well. The warehouse supervisor who made eye contact like a challenge. The grad student who said chain of custody, and then looked alarmed by his own vocabulary. He adjusted his tone, softened the part of himself that wants to lecture, and asked about misperception at a distance. He watched hands go up in the air, loosen its certainty by a degree. He could work with that. When Kylen's turn came, Miles listened the way he listens to jazz, half for the notes, half for the spaces. The kid asked the jacket question with the right amount of shrug. He didn't preach. He didn't smirk. He didn't act like the room owed him enlightenment. The jurors responded to that. They gave him the grace he had asked for by not asking. Miles felt a flicker of something he had not allowed himself in a while, admiration not tinged with professional jealousy. In a break, Andrea leaned forward and murmured, "He's not a martyr. Good. Martyrs mess up juries." "He's a mirror," Miles said, surprising himself. "Worse," Andrea said, smiling thin. "Mirrors mess up us." After lunch, they argued a motion in limine. Miles asked the court to instruct counsel to avoid the word flight absent clear evidence of evasion. He did not say walking fast in the cold was not flight because you don't give your opponent lines unless you have to. Granger granted the motion in the broad spirit and denied it in the specifics. "We'll take context as it comes," the judge said, which is how judges say when it live. The last thing before adjournment was a small exchange that left bigger footprints. Kylen moved to admit Whitman's statement as a present-sense impression. Miles objected on hearsay. Kylen cited 8031, with the clean aggression of someone for whom the number is a talisman. Miles countered with timing and reliability. Granger held his hand up, weighing nothing and everything. "We'll decide at trial," he said finally. Foundation, foundation, foundation. Back in his office, Miles stared at his opening bullet points again and made himself a promise. He would not say anything tomorrow he couldn't defend without dancing. He would not call a teenager a thief because saying it felt good. He would say print, proximity, probability, and let the jury build without mortar if they wanted to. And if they didn't, he would keep his temper and his tie and his plant and go try the next one. He had learned that most justice comes in aggregates, not epiphanies. He had also learned epiphanies arrive disguised as kids with policy numbers. At home, Leah asked, "Ready?" "As I'll get," he said. "Will you sleep?" "Like a prosecutor," he said. Badly and with one eye on the calendar. She kissed his forehead. "Try to do justice," she said, and looked at him to make sure he heard where the emphasis fell. He did. He went to bed and dreamt of a courtroom where the air didn't thicken for jokes and did thicken for numbers, and where a judge with golf on his calendar said ordered because the rule said 90 days and because somewhere inside the robe was a person who still enjoyed saying yes to the right lines. He woke before dawn, rolled over the floor of his mind, and put on the suit that knew what to do with his shoulders. The Friday hearing drew a crowd that didn't belong to the case. interns hunting a story to take home to roommates, a law professor with the kind of curiosity that substitutes for exercise, and a sprinkling of defendants waiting on other matters who sense something interesting traveling along the hallway tiles. Division A ran on punctuality. 9 o'clock came like a door swinging on greased hinges. Judge Warren Granger took the bench with the air of a man who believed ceremonies should be brisk so meaning could get a chance. People versus Dalton, the clerk called. Darlene gripped the strap of her tote twice and then relaxed it, as if telling her fingers that faith and fear weigh the same, so you may as well carry faith. Kylen stood when the case name sounded like a bell he'd been practicing for. Ready, Your Honor. Miles Carruthers rose at the state's table. Ready for the state. 2 minutes of housekeeping and then the first real thing. The subpoena return on AVL/GPS. The clerk handed up a stapled set. Granger flipped. You could watch the judge's face when he read something that mattered. A piece of him retreated to a private desk you couldn't see. The telemetry places Unit 21 off scene until 1956, Granger said. Come. Not accusatory. A barometer reading. Counsel, I'm sustaining the prior ruling. No references to a personal observation of the defendant operating the vehicle. Miles nodded. Understood. Kylen let himself breathe silently through his nose. Pillar 1, standing. Next, the latent print analyst. A door opened at the rear, and Dr. K.H. Patel entered with the walk of someone who had decided long ago to let her work be louder than her shoes. She wore a navy suit and a badge clipped on a lanyard like a passport. Miles took her through the prologue, training, certification, comparisons, and then backed away to let the science carry the room's confidence. On cross, Kylen chose gentle first. Doctor, we agree that fingerprints can't tell time? Yes, she said with the kindness experts reserve for smart students who phrase things correctly. And a print's presence on the steering wheel tells us that a person touched that wheel at some point, not when or why. Correct. He moved to the seam. Let's walk the envelope. At 21:11 hours, Collector Harlan lifts a partial latent from the wheel and places the lift card into an envelope. At 22:57, the evidence room logs receipt. Between those times, there's no entry indicating custody. The property ledger shows those times, she agreed. Do you know where the envelope was for those 53 minutes? I do not. Do you know whether anyone besides Harlan handled or resealed the envelope before it reached the evidence room? The envelope bears Harlan's initials over the seal. Anyone else's? No. Does your lab utilize blind verification? Yes. Was your comparison blind verified? Yes. Another examiner reviewed the prints without seeing my conclusion. He nodded. And still, the chain of custody remains incomplete on paper. The ledger has a gap, she said, choosing the careful noun. That does not necessarily indicate mishandling. Agreed, Kylen said. It indicates we don't know. He sat. He didn't need to bruise a careful witness. He wanted the jury to like her and love her limits. Judge Granger watched them both the way a carpenter watches a level. The gallery had stopped the small fidgeting that courts generate. Even the radiator seemed to listen. The last hearing item arrived with no fanfare. A motion in limine about the word flight. Miles argued to retain it. Kylen argued to forbid it. Granger split the difference in the way judges claim is Solomonic and sometimes is. Counsel will take context as it arises. I will instruct the jury that movement is not necessarily flight. Kylen glanced at Darlene. She tipped her chin toward the ceiling. Small victory. Pillar 2, firming. They reset for jury selection the following week. Reporters drifted out to send careful paragraphs that would leave room for tomorrow to contradict them. On the steps, a young intern asked Darlene, "Are you his lawyer?" Darlene smiled, weary and proud. "Today I'm his mother." That weekend, Brookmere wore a thin frost. Kylen turned his apartment into a rehearsal studio. He sat with Jerome at the clinic for an hour and practiced cross questions, editing out every why and every flourish that sounded like a TED Talk. He timed his opening to 90 seconds because the first 90 decide how much of the second 90 the room will hear. He walked to the Quick Mart with Shanice's subpoena in his back pocket and watched her pin it to the corkboard near the time cards with the solemnity such paper deserves. "You want me in a jacket?" she asked. "I want you in whatever tells the truth without apology," he said. She grinned. "Then I'm wearing my work shirt." Sunday night, the AVL map, the chain timeline, and the owner's words lay side by side on the table like a triptych. Darlene set her coffee down and tapped each panel. Lamp, she said, pointing to the telemetry. Gap, she said, touching the chain. Description, she said, lifting Whitman's line. Keep your voice flat when you say all three. The room prefers calm when you rewrite its mind. He nodded. Before bed, he wrote one more sentence at the top of his yellow pad. You're not up there to impress the judge. You're up there to make him comfortable saying the thing he knows is right. He slept in pieces and woke with clarity, the way ice sometimes shatters so clean it looks like a decision. Monday would be trial. The crack had appeared. His job now was to widen it until light came through without collapsing the house. Trial mornings begin before coffee and end after it's too late for caffeine to help. The courthouse breathed earlier than usual. Someone had propped open the heavy entrance door with a rubber wedge, as if the building had decided to be welcoming on a technicality. By 8, the hall outside Division A sounded like a train station whispering. Jurors arrived in clumps, some eager, some resentful, some dressed as if for church, others as if forced out of Saturdays. A woman with teacher energy and a canvas tote of snacks sat near the door and read a paperback. A warehouse supervisor with shoulders like stacked boxes studied the ceiling as if expecting leaks. A grad student in an over-ironed shirt avoided making friends. Kylen stood with his back to the wall and watched them like weather. Darlene anchored herself 5 paces away, half in the hall and half in a prayer that refused to pick a religion. Miles flipped through his notes with the controlled boredom of a man who knows pages perform competence. Officer Rios sat 2 rows back, uniform pressed into the shape of its own authority. Dr. Patel took a quiet seat near the aisle and pulled a legal pad from a neat tote. Experts like to have paper even when they don't need it. Jury selection began with the usual liturgy: presumption of innocence, burden of proof, proof beyond a reasonable doubt, reasonable, not shadow, rights and responsibilities. Then the questions that matter because they reveal which version of fairness a person believes in. Miles asked if anyone believed forensic science was infallible. 2 hands rose, one tentative, one earnest. He softened them gently into no with anecdotes about computers guessing wrong. He asked who had been a victim of theft, for hands rose and he watched the resentment like a stain. He asked whether anyone would give an officer's testimony more weight simply because of the badge. Hands hovered. He smiled in a way that asked people to be braver than their instincts. Some were. Kylen took his turn and made it feel like a conversation you might have at a bus stop if bus stops rewarded honesty. How many of you have ever touched something you didn't own just to see how it felt? Hands, then laughs that forgave themselves. If you've ever tried on a jacket and put it back, would you want a fingerprint to decide your future? Heads tilted. Can a fingerprint tell you when it arrived? A chorus of no. He asked about misperception at distance and told a story about waving to a stranger he thought was his cousin and realizing 3 steps later that the stranger was not his cousin and was, in fact, offended by friendliness. The teacher laughed out loud. The warehouse supervisor grinned despite himself. The grad student looked at his shoes and nodded, relieved to be human in public. Challenges used, alternates seated, oaths administered. Jurors took their places like passengers aboard a quiet ship. Judge Granger leaned into the mic. Opening statements, he said. State. Miles rose and told the room the story he still believed could be true. A stolen Audi, a teenager detained near the ditch point minutes later, a fingerprint matched by a qualified analyst to a reasonable degree of scientific certainty. He didn't promise observed. He didn't say flight. He stood on proximity and print and probability, 3 Ps that sound persuasive even when one of them is a shrug in a better suit. He sat with the discipline of a man who knows jurors punish overreach even when they can't define it. Kylen stood and decided not to pace. You'll hear about a fingerprint, he said, voice the size of the room but not larger. You'll also hear about a policy with a number that tells us where an officer was, a chain of custody with a hole that paper cannot fill, and an owner who described the person who took his car in words that don't fit me. If any one of those pillars shakes, the state's case cannot stand. All of them shake. The state called Officer Rios. Under Miles's direct, Rios kept his verbs narrow. Arrived, canvassed, detained. He avoided observed as if it were a puddle he didn't want on his shoes. He read from the report in pieces, pausing before the lines that had learned to blush. He described finding Kylen, moving away at a hurried pace, a phrase that sounded like flight had filed off its fingerprints. Kylen's cross came without theatrics. He held the AVL printout like a citizen carries a library card, calm with confidence that it would admit him. Officer, your unit's AVL records show your location at 1940 was 3 miles from Portman and 8th. Yes. And you arrived in the area at 1956. Yes. You did not personally see anyone driving the Audi. No. You did not write, I did not personally see anyone driving in your report. Silence. No. Dispatch's description said, black male in a hoodie and jeans. Yes. The owner described the person who drove away in his Audi as white. A muscle moved in Rios's jaw. That's what the statement says. You did not include the owner's description in your narrative. No. Thank you, Kylen said and sat. Dr. Patel followed. She explained powders and lifts and ridges and minutiae with the patient dignity of someone who had answered these questions so often she could chart the jurors' heart rates. The partial thumbprint matched, she said, to a reasonable degree of scientific certainty. She would not say absolute because she was a scientist and not a slogan. She did not roll her eyes when the grad student juror nodded too enthusiastically at the word AFS. On cross, Kylen built little stairs jurors could climb without help. You can't tell when the print was left. Yes. It could have been hours earlier, possible. Between 2111 and 2257, the envelope's whereabouts are not documented. Correct. Chain of custody gaps create risk, not certainty. Agreed. He left the limits in the air where they could be seen but not weaponized. The jury respected her. That respect could be borrowed if it wasn't broken. The state rested after a short redirect in which Miles reminded the room that the envelope arrived sealed and initialed. The lab double-checked, and science has patience even if defense counsel prefers drama. He didn't look at Kylen when he said drama. That restraint earned him a small nod from the teacher juror. The defense called Shanice. She wore her Quickmart polo with the logo stitched down after the U had tried to escape. She took the oath with a mixture of reverence and metallic annoyance. Reverence for the idea, annoyance at having to swear to words she'd been saying forever. What did you hear in the store the evening the car was taken? Kylen asked. The owner came in, Mr. Whitman, she said. Upset. Said, my car's gone. I left it running. Some kid jumped in and took it. He said, white kid. Those words. Kylen asked, not because he doubted her but because the court needed the exact shape. He said white kid like twice, she said. Like he was mad at himself and wanted the heir to know it. Miles stood for cross. Miss Davis, were you stocking shelves? Gum, yes. Focused on your work? I can stock in here, she said. A juror smiled. Miles pivoted. How long between when he came in and when officers arrived? Minutes. He was upset? Like he had done something careless and the world had reminded him how quickly it collects on carelessness. Lighting in the store? Fluorescent. The awful kind that makes everyone look tired. He paused. Thank you. He'd hoped to shake her. She nodded his effort back at him like a gentle teacher. The defense called no other witnesses. The room's air felt earned now, no longer a thing borrowed from ceremony. Granger dismissed the jury early with instructions to return for closings and deliberation. He leaned toward counsel. I'll hear any Rule 29 motions in the morning, he said to Miles, keeping the rhythm of fairness even when he suspected he knew how the song went. In the hallway, reporters waited with microphones like cut flowers. Kylen kept his hood down and his eyes up. He did not talk. He had learned the shape of noise and decided not to push it around with his hands. That evening at the table, Darlene cut an apple and salted the slices the way her mother had taught her. Tomorrow isn't a movie, she said. But sometimes a courtroom remembers how to be a stage with honesty for props. He nodded. He slept the way tired animals sleep. One ear cocked for predators the brain still believes in. Morning brought closings. Miles went first. A fingerprint on a steering wheel is not poetry, he said. It's contact. Common sense tells us people who steal cars often leave traces of themselves in the cars they steal. He conceded telemetry. He conceded no eyewitness. He leaned on the print and the proximity. He avoided the word flight like a man stepping around a hole he himself had dug. He sat with dignity intact and hope reasonable. Kylen rose. The state asked you to stand a verdict on 3 legs, he said. One says an officer saw me driving. The map says he didn't. One says the lab's print tells a whole story. The analyst told you it tells one word, touch, not when, not why. The third says the owner's description of the thief matches me. It doesn't. If pillars wobble, you do not build higher. You stop. He said nothing about golf or smirks or bias with megaphones. He trusted the jurors to translate from nouns. Granger called counsel to the bench for a quiet huddle only the furniture would remember. Then he leaned back to the mic. We'll reconvene at 2, he said. But he didn't send the jurors out yet. Counsel approach again. 2 minutes later, everyone understood that something had shifted behind the wood. The judge cleared his throat. Ladies and gentlemen, in light of the state's proof and the arguments presented, the court is prepared to rule as a matter of law. He looked at the jury the way you look at guests and tell them they don't have to stay for dessert. You are excused with the court's thanks. The room held its breath. Case dismissed, Granger said. Pillar 3 resolved. The crack had been an opening. Before the first juror ever sat, Kylen had practiced questions in the mirror with the ferocity of a person who has decided to make calm a discipline. He'd learned from watching Division B that judges detest preambles, and from Darlene that jurors detest being treated as performances. So he built questions like small, sturdy furniture. He tested the jacket analogy on Jerome, who offered, make it a hardware store too. People try hammers with their hands. It's in our wrists. He'd added, has anyone ever tested a tool in a store? Did the tool become yours? The teacher juror had smiled when she answered in voir dire, and the smile made the room warmer for the next 2 hours. He'd asked the wrong version of a race question in an early draft. Do you think police sometimes choose the wrong black teenager? And Darlene had crossed it out with a line that could have felled timber. You ask people to indict themselves, they'll indict the questioner, she warned. So he translated bias into perception under stress. The warehouse supervisor told a story about a night shift where he'd mistaken a coworker at a distance and apologized up close. The room got to be flawed and decent in the same paragraph. He'd reserved a challenge for the woman who said I trust officers always, not because he disliked officers but because always is a thief of nuance. He didn't use it. She watched herself say the word and softened it to almost always without being coaxed. He kept her. People who can edit themselves in public are valuable on a jury. He'd expected to strike the grad student. Podcast vocabulary can curdle into performance, but kept him because he blushed when he said chain of custody. Shame is a sign you know the difference between knowing and showing off. In the actual trial, the vibe of the room evolved with each concession to reality. Telemetry read into the record. Observed retired. Dr. Patel's strength paired with the humility of her limits. Miles's professionalism carried weight with jurors who didn't want the state to be the villain. Kylen's restraint carried grace with jurors who didn't want the defendant to be the story. When Granger dismissed the case, the vibe didn't explode. It deflated, gently, like a building relieved of pressure. The teacher juror looked at Kylen the way a good teacher looks at a student who has learned the lesson the hard way and then taught the class. The warehouse supervisor nodded once, a dock worker's benediction. The grad student stared at the chain of custody timeline as if it were a magic trick he could repeat at home. Members of the jury, Granger said, you are excused with gratitude. He meant it. Courts live on gratitude doled in teaspoons. In the hall, Shanice hugged Darlene as if they had been neighbors for years. He did good, Shanice said. You did good, Darlene answered. They both meant Kylen and themselves and the system as it could be on a good day. Miles approached Rios near the elevator. We'll talk about report language, he said, as neutrally as a man can when he has to invite another man to change a habit. Rios nodded. I'll change the template, he said, surprising them both. Good, Miles said. He turned and found Kylen. You argued well, he said. You tried fair, Kylen said. Small sentences can hold a truce. Judges rarely like to be surprised by themselves, but Granger was honest enough to admit that he had surprised himself. He used to tell new clerks that law is a ship and the judge is the ballast. Momentum belongs to the advocates, but stability is the bench's job. Lately, he'd felt like the ballast had hardened into habit. The golf jokes, the smirks, bad weather that had become climate. He stared at the telemetry map the way a man stares at an X-ray, grateful for bone and annoyed at the reminder that bone breaks when you insist it be opinion. He remembered the first time he'd fallen in love with a rule, Evidence Rule 403 in a second-year trial practice seminar, because it felt like a tool you could reason with. He remembered the first time he'd hated a rule, sentencing guidelines that turned men into boxes. When the kid, Dalton, had said the policy number cleanly and then stopped talking, Granger had felt the courtroom shift toward the right kind of gravity. Not the gravity of old men holding doors shut, the gravity of numbers that don't sweat. He had enjoyed it. He had then been angry with himself for enjoying something that should have been routine. He wrote a note to himself on stationery he never used. Ask PD to circulate memo on precise language in reports. Ban observed unless eyes did it. He paused. He added, schedule training on AVL for bench. Invite lab. Bring coffee. He folded the note and set it under the paperweight his daughter had made in 5th grade. A glass blob with trapped air bubbles that looked like the universe forgot to wipe the lens. Exterior, steps. News. A local station ran a 2-minute segment that said almost nothing and suggested everything. Teenager represents self. Judge dismisses case after questions about GPS, forensics, and eyewitness description. They aired Shanice's smile and Miles's no comment, and a shot of Darlene's hand on Kylen's shoulder that looked like the kind of sculpture museums pretend not to love. Online, the comments did what comments do. Weaponized anecdotes, praised and condemned caricatures. Kylen didn't read them. Darlene skimmed, sighed, and closed the tab. Miles's supervisor emailed good loss with the rare grace of a boss who understands that justice sometimes looks like a statistic moving in the wrong direction. Rios sat in his patrol car and stared at the word observed in a report template on the in-car tablet. He deleted it, typed arrived, then canvassed, then detained. He saved the template. He stared at the telemetry icon on his dashboard map and changed the zoom level so he could see more than streets. He could see how a story might be a line you didn't draw. Interior, apartment. Night. Darlene took down the chain of custody timeline from the wall like a holiday decoration whose season had ended. Kylen folded it into neat rectangles and slid it under the lid of the banker's box. We keep it, he asked. We keep it, she said. In case the next person needs to borrow a shape. He sat at the table with no papers on it for the first time in weeks. The wood had grain he'd forgotten. He found himself tracing it with a finger like a person who has just learned a new prayer. What now? He asked, not because he didn't know but because saying it out loud makes a path sturdier. Now you study, Darlene said. And you volunteer. And you go sit in Division B and listen for the moments when the room is about to lie to itself. Then you make it tell the truth kindly. He nodded. He took down the LSAT prep book from the shelf where ambition lives. He sharpened a pencil. He felt 19 and older at the same time. The official document arrived in the mail like all official documents do, 3 days late and printed on paper that could have been kinder to trees. Order, charges dismissed. The language was dry, the relief was not. Kylen walked the neighborhood not because he needed air but because he needed pavement. He passed the Quick Mart. Shanice lifted 2 fingers in a salute. He passed a barber shop where men argued about basketball in tones that conferred respect by volume. He passed the clinic above the pharmacy. Myra waved him in. We've got a line, Myra said. You want to help triage? You can say words like telemetry if you promise to translate. He sat at a folding table with a stack of intake forms and learned a new language quickly. Rent, notice, license, hold, visitation. He understood that the system had many rooms and that in some of them a policy number is a kind of door. In others it's a lock. Jerome leaned against the doorframe between clients. Heard about the dismissal, he said as if saying good weather. You keep your head? I kept it on my shoulders, Kylen said. Barely. Good place for it, Jerome said. Come back Thursday, I'll put you on the phones. At home, a padded envelope had arrived from an aunt. Inside, a tie. Not expensive. Well, for next time you need to look like a person the system respects by default, her note said. He tied it badly and then well enough. He hung it on the back of a chair like a banner that refused to be dramatic. Miles, in his office, filled out the dismissal numbers with a marker and then did a thing he didn't always do. He wrote himself a private memo on language. No observed unless observed. No flight unless flight. Describe don't infer. He pinned it on his board under due justice. He stepped back. The 2 squares of paper did not fight. They nodded at each other, colleagues. Judge Granger signed the order with a pen his clerk had given him for Christmas and wrote a second, quieter note to himself on the back of a desk calendar. Say ordered, less like a sigh. He circled it, then laughed at his own sentimentality, then kept the circle anyway. Reporters called. Kylen didn't pick up. He had learned to choose when a story ended. It ended here in public. It would continue in private. He and Darlene took a bus to the law school 2 towns over for an information session. The admissions dean said words that sounded like marketing. The students said words that sounded like debt. In the library, Kylen found a Corel with initials carved into it, WLH 2004, and placed his hand on the carved letters the way you place a hand on a shoulder you hope to lean on. He borrowed nothing from the stacks. He took a photo of the hallway where bulletin boards carried requests for clinic volunteers and a flyer for a talk on the confrontation clause that had been scheduled last year and postponed 3 times because weather is real and metaphors often aren't. On the ride home, Darlene's head tipped onto his shoulder the way it had when he was a kid on long buses. "Proud of you," she said, half asleep. "Proud of us," he said. "Weeks make events small if you let them." Kylen didn't let them. He placed the dismissal where it belonged, in reach, not in worship. He studied in the mornings when the building was quiet and the radiator generous. He volunteered at the clinic 2 afternoons a week, translating forms into sentences that felt possible for the hands that held them. He went back to Division A and Division B sometimes and sat in the back row the way church kids sit after they've learned the hymns and still want to hear a choir try. He watched another teenager plead to a trespass because the offer was good enough to keep his job. He watched a woman get a continuance because a witness had COVID. Granger granted it without sighing. He watched Rios testify in a different case and use verbs that would make a grammar teacher proud and a defense attorney respectful. Arrived. Canvassed. Detained. No observed without eyes doing the act. He took the LSAT in a windowed room that smelled like erasers. He loved the logic games more than was healthy. He wrote a personal statement that did not mention his case until the final paragraph and then only as an example of the thing he wanted to do for others, not a banner for himself. He asked Jerome for a recommendation because he wanted a letter from someone who had seen him carry paper and not just carry drama. Jerome wrote 3 paragraphs of praise that made him blush and a 4th of advice that made him steady. Remember to be boring when boring is righteous. One night, at the Quick Mart, he ran into Reginald Whitman buying coffee and a scratch-off ticket. Whitman looked at him, squinted, and then his shoulders dropped. "You," he said. "I'm sorry for leaving it running." "I'm sorry for opening it," Kylen said. They both laughed. Whitman held up the lottery ticket. "You think?" he asked, joking. "You already won the one that mattered," Kylen said. "Your words got heard." Whitman nodded, serious now. "They don't always," he said. "Not from people like us." "Who's us?" Kylen asked. "People who think our own mistakes deserve punishment and then discover punishment shows up faster than help," Whitman said. He paid for his coffee. "Be a lawyer, kid. We need more people who make rooms listen." Days later, Miles and Kylen passed each other on the courthouse steps. They didn't stop because stopping makes things heavy. "How's the plant?" Kylen asked, surprising them both. "Still alive," Miles said. "How's the studying?" "Still hard," Kylen said. They smiled like men on different teams who understand they are working on the same house. Spring arrived in Brookmere in the form of puddles that reflected a sky ready to try again. The clinic hired Kylen for a part-time intake coordinator position. "Pay is bad," Myra said. "Meaning is good." He said yes because he had learned to choose meaning when money offered him a shrug. The LSAT score came back like a letter from a college crush. It was good enough to be proud of, not so good he'd be insufferable. He and Darlene celebrated with cake and silence. The applications went out with signatures that tried not to shake. On a Sunday, he and Darlene rode the bus past the courthouse to the park. A group held a pickup soccer game. Children hunted the edges for dandelions. A teenager in a hoodie stood by the fence with his chin lifted the exact degree that says "I'm not afraid," or at least I won't let you see it. Kylen felt a tenderness he wasn't prepared for. He didn't want to be the teenager again. He wanted to be the adult who saw him without assuming his outline. He wrote goals in a notebook that wasn't yellow for once. Law school. Clinic. Trial team only if it doesn't turn me into a slogan. Build a policy class for high schoolers. How to read rules that rule you. Archive. Templates for motions, AVL, confrontation, chain of custody. Anyone can use. Mentor 2 kids a year. Never say observed if you didn't. Never let flight do the thinking. Teach judges to love numbers again. He added a last line in small handwriting. Be the reason a mother sleeps. The banker's box went to the top of the closet. He taped a label to the side. Dalton, Brookmere, dismissal. It was not a trophy. It was a tool that had finished its job and now wanted to rest until called again. On the first warm evening of the year, he and Darlene ate dinner on the stoop. Neighbors passed and said things people say when they don't know what to say. Proud of you, heard about it, about time the court did right. An older man from the next block, who always wore a hat and the air of someone unfazed by seasons, stopped and lifted his brim. You made the system look at itself, he said. It flinched. That's a start. Kylen thought about that, the flinch. He didn't want to build a career on provoking it. He wanted to build one on training the reflex out of rooms. He wanted judges to reach for telemetry not because a teenager asked but because the ritual demanded an honest map. He wanted prosecutors to write arrived when they arrived. He wanted defense attorneys to teach jurors that a fingerprint is a word, not a sentence. Night settled without ceremony. The bus sighed at the corner and moved on. Brookmere belonged to itself again. In apartments and houses and cars edged up on curbs, people slept and didn't, loved and didn't, decided and postponed. The courthouse would unlock in the morning and try to be fair. It would succeed and fail on a schedule that owed more to people than to paper. Kylen closed his notebook and looked up at a sky that had kept its distance through all of this, appropriately. He didn't ask it for permission. He didn't ask it for luck. He asked himself for work and gave himself a date on the calendar. Applications due. Clinic shift. Study group. He smiled at Darlene, who had fallen asleep on the top step, and tucked her sweater around her shoulders. He sat beside her so that if gravity tried something sneaky, they'd lean together. He wasn't a lawyer yet. He wasn't a hero either. He was a 19-year-old with a policy number in his pocket and a set of verbs he trusted. That would be enough to start. The rest would be hours and rooms and people and the kind of patience that doesn't confuse speed with virtue. Tomorrow he'd go back to Division B and sit in the back and listen for a word that had been doing too much work. He'd stand when the case name wasn't his and say, politely, Your Honor, the telemetry. He'd keep a lamp in his bag. He'd keep a map in his mind. He'd build a life sturdy enough that when the system looked at itself again, it would recognize him and not flinch.